I think, the BIA finally touched it and issued a pretty good decision for non-citizens, and that is this. Immigration judges nationwide in removal proceedings are ordering asylum seekers to file these sworn declarations. Yes, of course, you've got to submit the I-589. You've got to answer all the questions. You've got to provide details to those specific questions. But many IJs require these detailed, sworn affidavits, pages and pages long. When we do these, they can be 5, 10, even 15 pages, single space. You want to tell the whole story. And it's just cross-examination on a silver platter, right?
Mm-hmm.
You submit a 10-page declaration, DHS has it, and then you have your client on the stand testifying to the same thing maybe 3-4 years later. Quite frankly, anyone messes up a little bit.
Yeah.
Dates, names, it's just not possible to say the same story identically twice. Humans can't do it.
Yeah.
I mean, I guess unless you've prepared for 100 hours, but even then, there's always going to be some small thing. On the other hand, it serves a very significant, benefit. We do submit them on our own. It brings the client in to their story. It helps the court and the government know, okay, here's what we're talking about. But what happens when you don't submit it, or in this case, you submit it late, or actually in this case, you submit it only in English, even though the client speaks Spanish? Because, quote, because declarations are not a constituent part of an asylum application, an IJ may not deem it abandoned solely because the respondent did not submit one, end quote. The BIA has sided with, the immigration bar, at least not deeming these applications abandoned. The I-589 doesn't say you have to submit a big declaration. The regulations actually have documents and things that must be submitted with an asylum application. A declaration isn't listed, explained the BIA. It is a problem, though, the BIA doesn't say, because it would be inappropriate for them to say, they don't say that immigration judges can't order a declaration submitted. I mean, that would be an improper thing to do anyway. But what do you do then? You have to disobey the immigration judge. The BIA says it's just like any other document that you don't file. If it's not timely filed, the opportunity to file it is waived. So that's not really a bad result if you didn't want to submit the declaration anyway. Kind of puts removal defense practitioners in an awkward situation if they believe it's in their best interest not to have a sworn affidavit, and then you're ignoring or not complying with an immigration judge's order. But
aren't what large chunks of what the declaration? No, I don't do asylum law, but large chunks of what the will be in the declaration are on the I-589 with those multitude of questions they have in there.
Yeah, those not so much. You have little boxes, and you could expand, but you can answer the asylum questions to a sufficiently detailed degree without getting so much into the story. I mean, again, we did an asylum application last fall. Big important case, don't get me wrong. That declaration was 15 pages single space to give all the context, the dates, to really build it. We did that declaration. Declarations can be very helpful and important for your case. But sometimes maybe it's in your client's best interest not to have one. And here's the BIA saying can't deem an asylum application abandoned for failure to submit one. So, big deal.